So, Brendan, when we are prepping for trial, I know that everyone does it differently. And I think that, when we were in the DA's office, we'd get a war room. We had every single piece of paper we could possibly find, all of our witnesses lined up, and it was weeks and days and hours of work, sacrifices made, missing holidays, missing important events with our families, but it was important to us to make sure that we left everything out there when we fought on our cases to get the right verdict. And I don't know if you agree with me, but I think we do the same thing here,
Well, I think you're right, Maggie. What we know as trial attorneys is that it's not that you walk into court and you deliver a dazzling opening statement or a powerful summation and get the outcome that you're looking to achieve. It begins with preparation. So our approach, I think, here at our GLZ for preparing cases for trial is really a skill set that we learned as prosecutors, as homicide prosecutors working on challenging cases. We get into a room, we bring out every single piece of paper, single item from the case, and make sure that no stone is unturned.
Right.
We go through every single document, we bounce it off one another for our themes, for our ideas. We look at the evidence. How is this going to be received by a jury? And we will bounce that off one another. One of, I think, the tremendous tactics that we've used here is using focus groups as well. Bringing in individuals who we can vet through ideas about the trial, themes about the trial, issues with the trial, to get an understanding of how it's going to be received by a jury. But it's really key that the preparation is what delivers the outcome, and it begins not on the eve of trial, but many, many months before. In fact, in often cases, it begins at the beginning and the outset of the case to prepare it right out of the gate.
Exactly, and I think it's important because, when we were in the DA's office and we were on the vehicular crime response team, that was the most important thing, that we would get a call at whatever time of day or night, respond to a crime scene so that we could be there walking the scene as it was, with the cars where they may have been, if there was a decedent somewhere, where they landed, what happened, looking around to see if there's any video or anything like that, so that from the inception of the case, we had eyes on it and we knew what were our strengths, what were our weaknesses. And I think it's important when we are prepping for trial that, like you said, what's our theme? What are we going to try to instill throughout this entire trial to our jurors? What are our jurors going to think about the case? What are they going to think about the evidence, our witnesses? And importantly, too, it's something that we do both in our old life as prosecutors and here at Rappaport, Glass, Levine, and Zullo, that we list all of our issues. What are any potential issues, no matter how obscure they may be? What could possibly come up, and how do we rectify that? And we hit it here during our prep so that we're in court, and if this obscure issue may come up, we're not thrown off kilter. We're prepared. We have the case law, we have the arguments, we've spoken with our team about it, and we're as prepared as we possibly could be.
Yes, without a doubt. When we were prosecutors, we were responding out to crime scenes and seeing the layout of a crash then and there. That's not always an opportunity for us as plaintiff's personal injury attorneys, but the way that we do that same type of diligence is, if we are contacted early on a case, we send out a team of experienced investigators to get crime scene video, surveillance video, witness statements, things that are going to benefit our client later on at trial. We also know from going to scenes as homicide prosecutors that there's no substitute from seeing the scene. In preparation for trial, we've gone out onto the side of a road and watched the sequence of lights. We've watched how the flow of traffic, the layout of the roadway. We've visited scenes with our clients so that they can explain to us how an incident happened so we can understand it best and communicate that to a jury. And there's really no substitute for that.
No.
Those are key steps that allow an advocate in a courtroom to be able to communicate in a way that best represents our client and what happened to them and how they were injured.
Right, and that type of training is just ingrained in us. And I think that it is a skill that we brought to the civil side of things. And like you said, there's the saying that no one should know the case better than you. So
Without
when we
doubt.
walk in the courtroom, I mean, we truly believe that, no matter what happens, we know this case inside and out. We can handle any issue that comes our way, and we know when to strike at certain things that may come up throughout the trial.
I think one of the greatest assets that we have at our GLC is it's not just you or I on our own, or even you and I together. We have a team of attorneys, some of them experience of 30, 40, 50 years of litigating these types of complex cases. So one of my favorite steps in preparing for trial is when we moot or actually go through our opening or closing statements, because there's no substitute for saying it out loud and delivering it the way that you want to deliver it to a jury to ensure that you capture the meeting so you're persuasive and you can achieve the goal of getting the best outcome for our client when you go into the courtroom. And that's something that's, I think, differentiates us from other firms, from other practitioners, because we are individuals that fight for our clients, but we're a team here at our GLC that allows us to deliver results for our clients.
Absolutely. And, I'm sure you've experienced it just as I have, going into the courtroom on the first day of trial, you get a text message from everyone in the office saying good luck today, and throughout the entire trial process, someone's reaching out, how'd it go today? How'd the witness testify? How did this go? How'd that go? And I think that's important to get that support. And like you said, the focus groups, that's huge. Because, I don't know about you, but I bounced everything off my husband about, opening statements,
Sure.
Issues in the case, things like that, to get an outside person's perspective. I know I do that with our legal assistants here, just, hey, what do you guys think of this? And when we are mooting our openings or our summations, to get different perspective, because we see the case a certain way because we've lived it and we've breathed it. And so there might be things that are outside our purview that, Chuck might be like, hey, by the way, did you think about this? Or Mike Levine might say, what about this? So it's great to get perspective from everyone to truly bring the best case that we can for our clients.
Without a doubt, and sometimes over the course of a trial, legal issues come up or challenging novel issues come up during the trial that need to be dealt with in real time.
Right.
And if you're in the courtroom and you're on your own, that's a real challenge to take it on and make sure you can best put your foot forward to advance your client's case. Here, how many times have we been in the midst of litigation and there'll be an email that circulates among our team of saying, this issue has come up, how do we best manage it? How do we navigate it so our client is getting the best outcome here? And that's an asset to us, because immediately someone could be on trial and have a team of attorneys working to try to solve an issue that's come up. And that's something that's invaluable.
Absolutely.
And that's something for our clients that we're able to deliver for them because we have a team behind the individual in the courtroom.
Right. And even now, we've kind of taken on a new role of teaming up at trial, which I think is fantastic because, again, that's something we always did in the DA's office in the Vehicular Crime Bureau. And now doing it at Rappaport, Glass, Levine, and Zullo, it's just, it's a very comforting experience to bounce ideas off of another attorney, to be on trial with another attorney going through the stresses, the excitement, the failures at times, but you're going through it together in addition to everyone else here at the firm that's supporting you behind those curtains. So, it's really, I think, a very powerful thing to do, to have two attorneys walk in and, each of us takes a different role and we're extremely supportive of one another. And, if there's times where I might not know or I might not have experienced an issue that comes up, I might be sitting at the table with you or Brian or someone that says, hey, I got you.
There's also a real asset to when you're on trial, you could be examining an expert witness in some complex scientific area that you need to go toe to toe in order to advance your client's interest. It's really key that at the table, you have one of your colleagues listening. There are another set of eyes and ears in the courtroom so that nothing gets missed, so that everything that can be done to advance the case for our client is done right there in the courtroom, and that you have a team member that you can turn to and rely upon and know that they're also deeply experienced in this area. They're ready to try to advance the case for your client. Right. They have the interest of our clients in mind. And those are really things that having a team approach to these types of challenging trials really delivers results for our clients.
Right. And I think it's important too that, you know, not every attorney loves being on trial, but I think it's safe to say that we do. We love it. It's exciting,
Without
it's
doubt.
exhilarating, and we love fighting for our clients.